go ahead and get started. I'm Rob Pitkin, and I'm a construction lawyer. And so the topic that I chose with a little help from Eric Soriano is how sloppy contract provisions, collection procedures, and processes by estimators put my kids through college. So that's kind of the idea here is, hopefully to give you an overview. I know that there's a couple other legal seminars, some that dealt with delays and change orders, things like that, and there's going to be one on more in-depth contract provisions. But what I want to try to do is give an overview of everything so that you can get an idea of what issues that you're looking at could be out there. So I'll get this set up and hopefully it'll start playing here. So, the first thing is you want to look at the scope of work, and obviously you're all, you're estimators, you're people that are bidding work. You know that the scope of work is the most important thing, because if you end up missing out on the scope of work, it's going to affect your price, it's going to affect how you get it. This looks like you got a plan. So a couple of suggestions that I would make when you're dealing with scope of work is to use specific language for scope of work, similar to how you would bid the work. A lot of times folks they itemize out specific things that they're going to include, and they also list exclusions. That's good, whereas when you get the contract from the general contractor, Preston, it's going to say, you're going to do all the drywall work, right, Dusty? Something like that. And that's what he's going to send you. And you're going to send him a very specific bid, so you're going to have that battle as you go back and forth as to what gets included in it. As a subcontractor, you're going to want to make sure that you are very specific in what you include and what you don't include. And then the contract mirrors this.
You're not going to make any money off of us.
Make you guys start arguing right now. That's why I like having both generals and subs in the room. So, a couple of things that I've seen is making sure that you reference the plans and specifications that apply to the project. Sometimes there are plans that are preliminary, pre-approved by the city, and sometimes that people are bidding off that, and then there are changes, so you got to make sure that you update that, and that whatever you have in your bid is going to be reflected in the contract. I've seen those here. So. Okay. But feel free to jump in with any questions, because as somebody said, you got somebody here who charges by the hour who's here not getting paid, so feel free to jump in with questions. The other thing that you might think about is when you prepare a very detailed scope letter and bid, to include that as part of your contract so that there isn't any miscommunication. Because from the general contractor standpoint, the President will tell you, what they want to do is they want to make sure they got everything covered. They want to make sure not only that everything's covered within the division that you're bidding, but that there also are things that there aren't any gaps between your bid and somebody else's bid. So, for example, somebody who's doing electrical, communications, security, things like that, sometimes those might be bid as separate packages. There's something that might be, people might say, well, that's part of somebody else's package, I didn't include it, somebody else says that. Make sure that you have that conversation, make sure everything's covered in there. So, all right, and then the last thing I would always say is if there are things that you didn't include in your bid, you want to make sure it's not part of your contract, make sure that you list that in your contract. So that, again, the general contractor will know that. And the general contractor can either say, we've got that covered somewhere else, or I need a price for that, and give you a price for that, and we'll include it in your bid. So, any other questions on scope of work? Anything like that? That's probably the number one thing that I see is a big issue when you go from the bid standpoint to the contracting standpoint. Next is payment terms. And again, if you're just providing a bid for a project, then you may not be dealing with the payment terms, but that's going to be a very important part of protecting the that you bid, is to make sure that the payment terms in the contract are going to be accurate and beneficial to you. So one of the things is just to make sure most general commercial contracts are going to have monthly pay applications based upon schedule values, based upon an amount of retainage, things like that. So make sure that, you know, if you want to get paid more often, you can set that up. I've seen projects where that's happened. But if not, you might want to make sure that you're getting paid at least monthly. Second is, I would look at the amount of retainage. There's been a lot of reform about retainage laws. I'll give you a little bit of a summary. The legislature believes that retainage should be 5%, but it can be 10%. How's that? So most contracts I see is 10%. So the legislators feel good because they said it should be 5%, but then it ends up being 10%. But I've seen a lot of things where either, particularly if you're an early performing subcontractor, so if you're an excavator or you're doing foundation work or something like that, then you can get an early release of your retainage, you know, early on in the project when you're done, rather than waiting until the end of the project. That's something to look at. The other thing is getting retainage reduced from 10% to 5% when the project's 50%. I mean, I think a lot of general contractors are in favor of something like that as well. It does create a little bit of an accounting nightmare, figuring out who's retaining what, but that's why we have computers, right? So we can deal with that. The other thing that I would tell you is change orders. That's another piece that is important, is as you're going through a project, if there are extras or changes, try to get those billed as early as possible. Again, I think the general contractors will tell you that they'd rather get that dealt with while they're fresh in everybody's mind, rather than getting a bill at the very, very end that says, you know, okay, now I have $100,000 of change orders on a $150,000 contract. It may be all legitimate, but it's a little bit harder to sell to the owner. So there you go.
Right.
Okay, any questions on payment terms? I've got an hour, so I'm going to try to get through a bunch of stuff here. So, when we're talking about this, and everybody who's gone through construction has probably got conditional payment clauses. And there's really two different kinds, and I'm going to kind of give you a little bit of a summary of what the difference between the pay when paid is and the pay if paid is, because they're very important legally. So pay when paid is a provision that just, and that's a typical kind of provision. If you look at the AIA, that's what it's going to say. It's going to say that a subcontractor is going to get paid within so many days after when the general contractor gets paid. Okay, so it's just the timing piece of it. So it talks about when you're going to get paid. The other provision, and as a subcontractor, you've got to look out for this and know what you're getting into, and that is a pay if paid clause. A pay if paid clause says if the owner doesn't pay, who's going to take it on the chin? And a pay if paid says the subcontractor is going to take that, not the general contractor. So here's what you want to look out for. If you're a subcontractor and you have this in your contract, you want to make sure you understand what it means, and if you feel like you need to negotiate that, you need to negotiate it. So the magic words, and the cases talk about this, they say if it says that the contractor's obligations to pay is contingent, one of those fancy legal words, right? Contingent upon receipt of payment from the owner. So it uses a word like contingent. The other types of words that they use is that receipt of actual payment from the owner is a condition preceding, another great lawyer word, or two words, to the contractor's obligation to pay. Another way I've seen it phrased is that the contractor's obligation to pay is subject to receipt of payment from the owner. So if those kind of words are in there, it might say that the subcontractor bears the risk of non-payment or something like that. What that means is, if the contractor goes out, or not the contractor, but if the owner shuts down the project and doesn't pay the general contractor, and you think that the general contractor ought to pay you, then you may lose if you have that kind of language in your contract. So you need to know that up front, and either try to negotiate that out or know what you're getting into. You know, that could be a reason why you want to understand what the owner's financial arrangements are to pay, whether there's a bond on the project. A bond can help you get paid even if And then you also have mechanics lien rights on a private project. And so those things would be things that you would want to know and be able to make sure that you protect your rights on that. Yeah?
If you sign a contract that's, for all intents and purposes, a pay if paid, do you forfeit your lien rights then?
No. Both Missouri and Kansas have specific statutes that allow you to pursue a mechanics lien, even if there's a pay if paid.
I've seen it's very typical that I see both in the contract. One is they will pay us when they get paid, but only will pay us if they get paid.
Yeah.
So, I haven't seen a contract lately that doesn't have both of them. So which contract is it if it has both?
That would be a contract interpretation issue.
For time, it's pretty interesting. It's always fun to sit back and check it.
I would say that, yeah, exactly. Most contractors have a legal degree and they never went to law school. But they probably pay more than I did for a while. But I think if it has that kind of language, it has the pay if paid type language, that a court is probably going to enforce it as pay if paid. Because I think the one scenario says when the contractor gets paid, he has an obligation to pay you within so many days. So that if he doesn't, you can shut down your project, you can give notice of default, etc.
As a subcontractor, a lot of times we don't know who the great actual customer is. So paid if paid, I can't do a credit report on them.
Right.
I can't run their credit, I can't find who they are unless I can find, maybe I can get the title and see who the company. But I don't have a contract.
Usually,
So I'm extending credit.
a lot of contracts you're entitled to see the contract with the owner. So you could ask for that at the time of the contract. Usually it says you have a right to see that. And you do have a right to see it because it usually incorporates provisions of the private contract. So you ought to ask for that. But particularly if they have that language, maybe one of the ways to approach it is the contractor, general contractor saying, hey, I think this might be what I heard in the seminar called pay if paid. Can we just rewrite it for this? And they say, no, we can't do that. And say, well, then I need to see who your owner is and do a credit check. Because they'll say, sure, I'll modify that for you.
This has happened.
So, any other questions on that? And again, there's a lot of contracts. It's a non-issue, but it does come up. For those of you around this area, the corporate parking project, that's what happened. Was that the developer went out of business, the original developer, and there were subcontractors who didn't get paid, and the provisions, the contracts had to pay if paid, and the judge enforced those and let them file a mechanics lien, and then they fought over who had rights. The mechanics lien claimants or the lender, who's Bank of America, and then there was the bond. So yeah, that was one of the reasons why my kids got to go to college too. Was that okay? And then I mentioned that the subcontractor bears the risk of non-payment by the owner. All right, anything else on that? Okay, the next one I would say is the standard of care. And I don't see this a lot, but every once in a while you'll see a contract. This applies whether you're a general contractor or subcontractor. And it talks about the standard generally, from a legal standpoint. Just like a doctor, just like a lawyer. You go to somebody and you think, well, my doctor, something bad happened. I went to the doctor, something bad happened, so it has to be malpractice, right? Well, no, because number one, sometimes bad things happen, and number two, you're not entitled to the best doctor, you're just entitled to a competent doctor, right? Reasonably competent. Same thing in construction or design or something like that. That's the legal standard, okay? And so the typical warranty language in the AIA talks about that you use materials and equipment that are of good quality and new, and that the work will conform to the requirements of the contract documents and free from defects, okay? So it basically says you didn't screw it, all right? That's what you are agreed to do. Sometimes, the contracts will have things like best quality. Okay, so that means you do better than 99 out of 100, but one person beat you, then you didn't do best quality. I mean, it's something that I would look at as a lawyer and say, okay, that's something that you could fight later on. So it's an invitation to a fight. So I would look and see whether or not there's something in there that talks about your standard of performance has to be better than the ordinary contract. Okay, that's just something I would look out for. Any questions on that? All right. Liquidated damages. They're always fun, aren't they? That's something else I would always look for in every contract because it's something that in the event of not meeting a performance date is going to be an argument, and owners and general contractors, owners primarily I would say, love to enforce some kind of liquidated damages. So basically what it does is it obligates a contractor to pay a specified amount per day following substantial completion if the project's not done. And the amount is something to look at. And I've seen a couple of different things on that is, I've seen some where they give a grace period. So it could be a 30-day grace period. So if substantial completion is November 1, you might get a grace period before liquidated damages are assessed. Number two, it could be that the first period, 30 days, is either higher or lower, kind of depending on what it is, and then it gets either higher or lower after the 30 days. But the thing to remember about liquidated damages is that they're generally going to be upheld by a court, and especially on a public project. So if you're dealing with a county or school district or something like that, the courts are generally not going to revisit that. There's many arguments you can make on a private project. The whole point of liquidated damages is to quantify what the owner's damages are going to be if the project isn't completed on time. But if the owner wasn't going to move in, wasn't going to utilize it, and kind of a no harm, no foul, you can kind of argue that a little bit, although the judges, my perception has been, the judges don't like to hear those arguments. They'll just enforce it, but it's at least something that you can try and negotiate on the front end, which is what I would recommend. So, right, any questions on liquidated damages? Okay, another one to look at when you're looking at your contracts or you're bidding a project. And sometimes you're bidding a project with a standard contract where they say this is the contract you agreed to enter into if you're awarded this project. And that's where in your bid you need to say, I want to revise that, I want to revise that, I want to revise that. So that's why part of it is from an estimating standpoint we need to do that. So no damages for delay is a clause in a contract that basically says that the contractor or subcontractor is not entitled to any money that results from a project delay, but you get an extension of time, okay? And sometimes that's okay, and sometimes that's all you need is an extension of time, and you don't need really any more money. Sometimes, maybe most of the time, time is money. And so I would be reticent to have a clause in a contract that says that you don't get any money for delays, because if the owner, particularly if you have to mobilize to a project and you're incurring, especially a general contractor, incurring general conditions and operations at the site, you're assigning people to the site, man the site, superintendent, the project manager, etc., trailer, storage, all those kind of things, and the drawings aren't ready for 6 months. That's a real cost that you should be able to recoup. And a clause in a contract that says no damages for delay could keep you from recovering that. So that's something I would look at the time that you're bidding a project and certainly at the time that you're contracting. And what I would say too is that the owner is not willing to waive their damages for your delay, liquidated damages, then it would be unfair for the contractor. So that might be an argument that you could use with an owner when you're trying to negotiate that piece, is to talk about, look, let's try to do something that's fair to both sides. If you want damages, if I don't pay it on time, then maybe I get a bonus if I get done early on time, or maybe I get damages if you delay me. So,
is that easily enforceable, or do you have to tie it to a critical path schedule if you want to try to argue for damages, for money damages?
It would be enforceable. I mean, basically what you have to do is you would have to show, like you said, a critical path, that there was something that happened, whether it's the owner responsibility. I was talking to some guys at lunch and said, on a project, the owner does buy a lot of risk because they've got, there's problems with the plans, there's problems with their design, there's problems with the utilities, problem, that's all on the owner. And so a lot of owners don't realize that they have all these problems. you're bidding work or contracting is choice of law and form selection. So basically, in contracts, and most contracts, they try to do this, particularly, for those of us that are here right on the state line, it kind of matters whether or not it's a Kansas law or Missouri law. And a lot of times the contractor would just say it's the law of wherever the project is. And so that's its own discussion on what law applies, when and how, and all that. But you want to look at your contract, because sometimes you'll have a contractor from out of state and they'll say that, Hawaii law will apply. Well, I'm pretty sure that you don't know what Hawaii law is, and I don't know what Hawaii law is. I would have to look it up and understand what the differences are, but that could be significant depending on the issue. Sometimes that's put in there just because they want the same law to apply to all their projects, which I understand. And sometimes it's done for a nefarious reason, because there's something in that law that would be to the disadvantage of somebody who doesn't know about it. So what you need to know is that you can put something in your contract that says any kind of law can apply. And a court will probably uphold it, because that's your ability to do that as part of the contract. Yeah?
I have a question about it, kind of the back one, but, so you did a job, you have no schedule, you did a job, you contract a job, you have no schedule. Contract, you started, and then you get a schedule, and it shortens your time. How do you handle that? So in your master contract, is it typically some two contracts, or three contracts? Is a master contract that's for the whole company, that goes over and you decide job specific contract.
Right.
Your master contract will typically say you have to follow the schedule and pay your penalties for if it's not done. But it wasn't followed when you started.
Yeah, that's always hard, because, I've seen it in Dusty's life down here. I've seen it in a bunch of different ways.
It's happening to me a lot.
Yeah.
It's happening to me a lot.
Yeah, no, I hear you. A lot of times it just says, the schedule dated September 1 is the schedule, and you have to abide by that, and you have to abide by any updates to the schedule. Okay, well a court is going to enforce that reasoning. Now, if they change the schedule from being 365 days to 270 days and don't want to pay you for that, the court's probably going to not make you abide by that. But that's where you're going to have the choice of, well, do I accelerate, submit a claim? That's one option. Or am I going to be late and defend? And they apply,
That's not some money both entirely you can hold your kids through college.
Exactly. Well, I don't have any more kids to go, but I may have grandchildren. So.
They go to Harvard.
Yeah, exactly. Okay, so choice of law, if there's nothing in the contract that says what law applies, then usually where the project is going to be the law. So.
Is it as simple as just crossing it out, signing a contract, or putting your provision where you want, if you want to say, because we had one contractor that was out of Arkansas, and it said in the contract that everything, any court deals would take place in Fayetteville, Arkansas, and right to court. Well, that's a long ways from here to go.
Right. And that's the next thing that we're talking about, which is form selection. So the law is like what principles of law are going to apply. And so, like for example, in Texas, if you have a lawsuit between two parties and there's a contract that doesn't talk about attorney's fees, then you can collect attorney's fees if you're in the win. You just have a law that says that. If you're in Kansas or Missouri, you don't get that. But there are prompt pay. Anyway, there are prompt pay laws, but essentially that would be a difference in the laws. Forum selection is exactly what you're talking about, which is where is the lawsuit going to happen? And that can be maybe even more important than what law applies. Because, I've seen things where, they have a project down the street here, and they want you to litigate in Massachusetts. Well, number one, do you really want to hire a lawyer in Massachusetts? If you have a lawyer here, do you want to have to travel there, et cetera? But again, in general, when you're dealing with contracts, the thing to remember is you need to assume that if it's in the contract, that the judge will probably more than 50% enforce it. Not always, but more than 50%. So the best thing is don't get it in the contract if you don't like it. So, so the other thing that I'll mention here is just ADR, and that's alternative dispute resolution. That would be like arbitration. And And so a lot of times I see that too. I mean, I had a case recently that I wrapped up for a client who's located just north of the river, who was contracted with a general contractor who did federal government work, who had an office north of the river. The project was at an Air Force base in California, and we had to go arbitrate it in Ohio. You know, but and a lot of times when you're dealing with arbitration, a lot of times even courts are going to be more reluctant to intervene in that because they're going to say, well, you agreed to go to Ohio for your arbitration, so it's not up to me to change it. Whereas at least if you have a lawsuit, the judge might say it makes more sense for the case to be here. Yeah.
I did not agree to go to arbitration because I had an issue that was extremely erroneous. Their next step is to be to sue me in the state we did business, correct? They probably couldn't sue me in the state there, right? Because the business did not take place there.
Yeah, so the question really has to do with where you can sue somebody. So if somebody comes to me and wants to sue somebody, the number one place I can always sue them is where they are located.
So they have to come and fight.
Right. Number two is if it's a project, I can probably sue them where the project is if that's a
Or
different place.
the place of business would be
Right.
where the property is.
Correct. Now, if there's nothing in the contract and they try to sue you where they are, there's some arguments they can make. It's called long-arm jurisdiction, which allows you to go to a different state. That's a harder case to win, but I've seen it, people try it all the time.
We're lawyers to that.
That's right. All right, another thing, and I think this is an important thing to try to make sure that you have in every contract, is something that says specifically that you have the right to suspend or stop work, usually for non-payment, but it could be for any kind of breach. And it's surprising how many standard form contracts don't have this. It's kind of just assumed that you're going to get paid, and this doesn't mean that, you know, if you have a dispute over a change order that you can just stop work and walk away from it. That's not what that means. What it means, though, is, you know, if you're out on a project and you haven't been paid for 2 months, your only leverage is to stop work, and you should be able to do that. And general contract law would give you that right, but there's no clear line. You know, the general contract law says when it's a material breach, a significant breach, you can be relieved of your obligations. It's easier if you have something that says, I have to get paid within X number of days. And if I don't get paid within that number of days, I send a notice. And if that's not cured within 5 days or whatever, I have the right to suspend operations and stop work. Because you want that in there. That's your leverage. And then that way you're just following the contract and doing exactly what's in there. So without something like that, you're at risk on whether or not you can do it. You might be right, but you might be wrong. And that's a big risk to take. So I put in something here too. Make sure that you comply with whatever is in the contract without notice. And just make sure you walk through each step of that. Usually it's a reminder that says, hey, the contract was supposed to be paid by Tuesday, it's Wednesday, you let me know when this is. P.S. This is a demand for payment. And then if they don't respond, then you say, okay, under the contract, I now have the right to suspend work. I'm going to do that on this day unless I get paid. And then that way you can work through.
They don't have the right to come back and supplement your work and charge you what it costs the contractor to come back and get the job done.
Not if they breached. Not if they breached, they wouldn't have the right to supplement your work.
I didn't hear what you said. What did you say?
You say you didn't get paid, and you were going to suspend work and stop. I asked if the general contractor doesn't have the right to come in and say, okay, we're going to come B to come in and finish your work. And
It's happened to me.
And then bill you for it.
Oh, yeah, and then I said yes to
He
Well,
said-
yeah, I mean,
Yeah, he says no.
Yeah.
a lot of construction cases are, you know, you're saying, I stopped work because I didn't get paid, and you breached, and I followed everything. And they're saying, no, you breached, I just supplement you, and so therefore you owe me money, and so you go in and you want this, and they want this. So that's a lot of cases. So part of it is, you know, if you have something specific like this in there, you're going to be on better ground than you would without it. So the other thing that I would look at is if you have a right to stop work, consider adding something that says that you could terminate and sue for lost profits. Because sometimes it doesn't even say that. And then, you'll get the argument that, well, okay, well, I didn't pay you, up to the date that you worked, but once you left, I have to pay you. So if you have something in there that says, if I have to terminate due to your breach, there's a poison bill is how I would terminate. But they have to pay you something extra, and that's worth thinking about. All right, any other questions on that? All right, so this goes really right into the termination, because that's really the next piece. And so there's two types of termination. There's a termination for cause, and it's either by the owner or by the contractor, subcontractor, or a termination for convenience. And so termination for cause basically is, somebody's not working on the project, they're not doing adequate work on the project, they might be getting supplemented. The question is, at what point do you get, does that become a termination, a basis for termination? And I will just tell you, because I've dealt with a lot of termination cases, and they're very hard to win if you're the person terminating something. Whether it's a general contractor terminating a subcontractor or an owner terminating a contractor. I mean, generally, the way the courts are going to look at it is if somebody's costing you money, then you withhold the money, you supplement, you sue them for the dollars, etc. It's a money thing. In order to terminate somebody, that's a pretty drastic thing. And if somebody's not showing up at the project, that's pretty easy. I mean, if they literally, if they only have 3 workers show up and they need 15 to maintain the schedule, you can supplement, right? That's a dollars thing. That's not necessarily a termination. So termination is really, really a hard thing to do. Now, most standard contracts then have a clause that say, well, I can terminate you for my convenience, which I think originally meant, if the project shuts down or something like that, it's a way to essentially terminate the contracts downstream. But the way that they're used is, you can be out there and you can work 50% on a project and they can say, terminate for convenience and hire somebody else. And a lot of contracts say that they can just do that. And so I don't think it's fair, but it is what it is. So a lot of times there are...
Is that still
Yeah.
termination for convenience? And is that, you're saying it doesn't withhold, or if that's written in termination for convenience?
My experience is that the cases have upheld termination for convenience for any reason.
Okay.
The contractor...
Just as long as it says that, that's
Correct. Correct. I mean, there's some cases that talk about, you've got to have good faith and all that. I mean, but they're hard to win. I mean, basically, most judges are going to say, look, if there's a clause that says I can terminate you for any reason, then I can do it. And so they can do that. So what a lot of times makes sense is, this applies to the general contractor and subcontractor is try to, again, put something in there that says if they do that, they have to pay a little extra, right? Because if you're 50% done, you didn't plan to do just 50% of the project. You plan to do 100%. You may have, turned down other work because of your backlog, etc. So maybe put something in there that says they have to pay you an additional amount if they want to do that. That would at least give them some pause, give them a poison pill as to why they might not want to do that. So something to think about. Okay, so those are kind of like, the top things I would talk about contracts. There's going to be another seminar right after this on contracts that's going to go through more contract provisions, etc. So I want to cover those in case you didn't come to the next one.
So what would happen if you got terminated for convenience or whatever, but you had a lot of material to lay down? You take that away?
Probably, it depends. So if it's something you could build for as a stored material, then the contractor would get it. So they would get it there. If it's something that you just stored there because you were planning to do that, then you would be entitled to it. Now, if it's something that's unique to that project and there's a restocking charge, you probably could get some kind of claim on that as well. Or if it's a unique product, I've had that happen before. Somebody has a custom-made product, and again, that's a reason why you want to try to get that bill early on as a stored material because then you have to pay for it. So, yeah.
Most contracts don't offer useful material very often.
Right. I know.
Unless they're specific, so I mean, that sounds good, but this is really not the real one for what I'm seeing. I only work as a sub, and all I see is general contractors contracts. That's all I see.
Right.
From every different rendition, and hundreds of different lawyers, and they're all unique in themselves. I had a situation where a job-specific rebar bent for a job, and I could not bill for delivered product, but I was not, ended up not being completely retained, the contract didn't go through, it would pay me for the rebar. Even though it was made for that job, it was still the job. Probably the people that had the right to sue it, correct? If they used it.
Oh, if they used it, absolutely, yeah. And in fact, on there was a project down in Plaza, the West Edge project, who had ended up shutting down, and they ended up tearing down the building and building a new building there. And the judge in that case actually let there was some marble from China that was very unique. It was cut specifically for that job. Got delivered, never went on site, never got installed on site. So there was a real question whether or not they would be able to collect as a mechanics complaint in that case. And the judge did allow it, which was unusual.
But we're better off, it's probably better if we're on site.
You're better, if it's on site, you're better. Yeah. If it's installed, you're golden. If it's on site,
If it can be returned, it's always better off return.
yeah. If it can be returned, I would return it.
Looking at an early completion bonus project, you can show that whatever stage you're at, say you're 60% done, and then you can show by your schedule that you can make that whole
That'd be a good argument. Yeah, if you could show that you would have made it, that's where it would be, the argument on the other side would be, well, that's just speculation, et cetera. But, and then the other argument would probably be, well, but they have the right to terminate you, so you can't challenge the termination, and so it's a matter of damages. And usually in the clause of termination, it'll say something like, you have the right to get paid for all work up through the date of termination, which wouldn't include that. That'd be the argument. But that might be something that you try to negotiate. Say, if you terminate me, and what I've done sometimes is, and it depends on the contractor, but my feeling is if you've got, if it's $1 million contract, let's say, and you get terminated less than 50% done, that's a lot of money you left on the table. So you want some money there. If you're 80 to 90% done, and for whatever reason, they terminate you and they hire somebody else to finish it, you're not out as much. And so maybe there you're willing to walk away from that. So sometimes I've seen where they say, if you get terminated early, you have a bigger penalty. If you get terminated later, it's a lesser penalty. Because I guess, owners like having that right, and contractors probably do too. They want that right to be able to replace somebody for whatever reason. I've had contractors call me up and they want to terminate this up, and I tell them and say, it's a hard thing to do, and you've got a really good basis for it. And they may be slowing down the project, but most of the time they're going to look at that as a damages claim. And I said, if you terminate them for convenience, then you're just done. And then sometimes they just say, I'd rather do that. Because it's going to cost me a little bit more, but I'm going to get rid of that. So sometimes I choose. All right, so after your contract, obviously, you're at the end of the project, and you want to get paid. So here's just some good principles to keep in mind for collection processes and procedures. And one is getting the agreements in writing. Now, in a commercial context, that's really not an issue, and generally people do that. But sometimes, there are smaller projects. Sometimes there are service projects, things like that. Trying to get something, even if it's a signed bid. You just do a bid for it. Somebody signs it and agrees to it. Then that's a written contract. Most contracts, contrary to common perception, do not have to be in writing. You don't have to have a written contract. You can have an oral contract where we talk about it and we agree on it, and it never gets written down. The advantage of the writing is you can't argue about what the terms are, and that's the reason why we want to get it in writing. So other things that are good to get into your file because you may need it later on are a legal description of the real property. That's for mechanics liens. So you need to file a mechanics lien if your time period is short at the end. You have a payment bond. It's really good to know if you have a payment bond on a project, because that's another pocket, particularly if the contractor is on shaky grounds financially. And sometimes that happens. Sometimes there's a contractor that is in a tough financial situation, and so they're paying very slow because they're having cash flow problems. Well, having a payment bond and keeping the surety informed if you're not getting paid timely can usually help them, because the surety has the right to essentially step in the shoes of the contractor, take the money from the owner, and then pay that to the contractor, to the subcontractor. So, loan verification and documentation, again, knowing who the lender is, giving notices to them, because they have a vested interest in you getting paid as well. They know that particularly if you're a subcontractor, if you're not getting paid, then the lender wants to get paid, because the last thing they want to do is finish up the project and have subcontractors show up and have claims. Again, and most people know this, but I think it's important to know whether you have a prime contractor or a construction manager. I mean, it's your contract with the owner, it's your contractor being held by a prime contractor. That's important to know. And then, particularly if you're a lower tier subcontractor, so if you're providing some services to a subcontractor, for data work for an electrical contractor or something like that, then know who all is in the chain, so you can make sure that you're talking to them. If you're not getting paid, you can figure out who the problem is, who's the holdup. So, and then the last thing I would say on just the collection procedures, the processes, is to know when you first started working on the project. That can be an important date in mechanics liens, and so recording that date early on, and it would really be the first day out on the site, can be helpful. All right, so after you've kind of gone through that, you haven't gotten paid, you're talking to your lawyer. The advice is don't let your mechanics lien and payment bond rights run out. I mean, I can tell you stories about a client who called me up, done good work on a project, didn't look like they were ever going to get paid, they filed a mechanics lien, it sat out there for months and months and months, and one day they got a call from a title company and said, we want to verify the amount of your claim, and they got a check. And if they would have not have done that, they would have not gotten paid. In the Corbin Park case, in both the West Edge case and the Corbin Park case, there were some pretty notorious projects around here. There were contractors who gave up, that literally just gave up. They didn't want to pay any money, and they would have made more than they would have ever spent with their attorney on those projects. Now, it's also possible that you spend money and you don't ever get anything. But my advice is always make sure you preserve those rights and don't give them up unless you make the conscious decision to give it up. Because if you miss a deadline, you just gave it up. And those are the ones you're going to kick yourself out. So basically, a quick summary of the mechanics lien is something that gets filed on a private construction project, and it's like a mortgage. So it's the same thing as a mortgage that you would have on your house. But a contractor has the right to file that and say, I didn't get paid on this project, and so I have a lien on there as well. It's most helpful, really, when the owner's the problem. I mean, it's, I've had cases where the owner was the one who wasn't paying, and I was representing the general contractor, and we had a meeting with all the subs and said, I'm going to help you file liens. We're going to flood these guys with liens because we want everybody to get paid. And in that case, all the subcontractors got paid, and the general contractor had to go slug it out with the owner. And we won, but the advantage for the general contractor was he didn't have a $3 million receivable with all his subcontractors. He just fought over his portion of it. And so it was a little bit more manageable. So that was very helpful in that case. And it can be really important when whoever your customer is, whether it's a general contractor or the owner, goes out of business or files bankruptcy. I just got done with a case in bankruptcy court where this happens all the time in bankruptcy court. You're a subcontractor, you haven't gotten paid, and you file a mechanics lien. And in the context we had, the owner paid us directly because they wanted to remove the liens, And then the contractor filed bankruptcy, and the trustee in the bankruptcy case said, hey, you got paid, and you shouldn't have gotten paid because my client should have gotten that, and you should have gotten paid pennies on the dollar. Well, in that situation, in fact, we had liens, et cetera, we were able to win that case. But that's a situation where, you know, having your lien rights, et cetera, is going to put you in a better legal position. So mechanics lien applies to a private project, so a private owner. If it's a county, state, city, school district, whatever, they have to put up a bond, and then you can't lien it. You can't file a mechanics lien. Obviously, you don't want mechanics liens filed against you know, the local school or something like that. But there's a bond that's out there that serves the same purpose. So just in terms of, they're really short. I mean, they don't seem that short, but they are really short. I mean, if you finish up your project, you know, today, and you submit your final billing in a month, and they're telling you that the retainage is still hanging out there, et cetera, 3 months can go by really fast. And so you need to know when the last day was that you went out there, because that's important, not when you build it, but when you last went out there. Yeah.
Last day worked, last day on site. What's the?
Well, it depends on when you call me, which day we're going to use.
Well, what would you want?
The ideal date to use when you docket these deadlines is essentially your substantial completion date. So if you're the carpet guy, the last day you lay down carpet, not the day you went out there to do anything else. Use the earliest date possible, because that can't be argued. But if you're out there doing punch list, probably covered, but somebody's going to argue it's not. If you're doing warranty work, that's pretty clear it's not going to justify the time period. So use an early date as possible.
Some substantial completion and mobilization. I mean, you know, when I get done with work, it doesn't mean my equipment's off the job. It doesn't mean I'm
Right.
Would you prefer that when the day that we're working to mobilize it? Would that be the, I mean, what they, when the actual, when the delivery walks off, or when the boss says they're done?
The mechanics lien statutes say within 3 months of your last day of work on the project. So it's really up to the judge to decide what that is. And so what I would always tell you is, you know, if you're the drywall guy, it's the last day on drywall. If you're the electrical guy, it's the last fixture you put up. That's the day you want to use. Now, a lot of times somebody's going to call me and I'll say, well, when did you last do that? Well, it was this day, and we built it this day. I'm like, well, that's too late. We're too late now. But when were you last out there? When did you have equipment on there? And I've had cases where air conditioning, HVAC, you know, they had everything installed, everything was there. They just had to show up 3 months later and get it all started up, right? The judge said that was okay. So, I would say you try to use the earliest day, but I'll use a different day if I have to, and try to get that done. So, but it's short in Kansas. It's basically 3 months for a subcontractor, 4 months if you have a contract with the owner. So you could be a trade and have a contract with the owner, you get 4 months. You can then get it extended to 5 months. So Missouri is just 6 months. 6 months. So it's a little bit longer time. So I won't bore you with how you do that, but basically what you have to do is you have to get something filed, and then you have to file a lawsuit within a certain period of time after that. Kansas, it's 12 months. Missouri, it's 6 months. That's why it's fun being on the state line. But basically the process is that, you know, you have to go in and prove that you have a valid claim, you have to prove that you have a valid mechanics lien, and then if that's the case, then the court has to decide who gets paid first. Is it you, is it the lender, is it somebody else? And that's kind of what the cases are. But most of the time, those get resolved. Because if you have a valid claim and a valid lien, somebody's going to pay you, whether it's the lender, the owner, the contractor, or something. All right, change orders. We talked a little bit about this earlier. Change orders, it's important, I think, to monitor those during the project rather than just lump in a big change order billing at the end of the project. In that case, that's one of the things we're dealing with. I'm representing the general contractor. Written authorization is really important. Again, you have to look at your contract, what it requires, et cetera. If there's extra work, different work, et cetera, you should get paid for that. But again, just try to handle it in a way that is good. Preston's just had enough. And if there's things that are disputed about change orders, et cetera, then you know, I would say you want to start the claims process. You know, submit a claim, et cetera. Just don't want to get your contract passed. So, okay, so litigation, that's kind of like the last step. And that is, you know, the best thing is generally negotiate a settlement. So if you've got a claim, get together, sit down, you know, get together with the decision maker and try to hammer everything out. That's going to be the best thing for all involved, and it's going to save you a lot of money. And but sometimes it's not significant enough, and people just write it off. They just say, I don't need to go through that. You file a lawsuit or arbitration, or I would say consider having a wait for a miracle. And I see a lot of clients that do that. They just don't do it sometimes. That happens. So just prior to a lawsuit, I think that there's a good checklist that you talk to your folks about. You know, phone call. Sometimes people are just slow on getting paid. Sending letters, hiring an attorney to send a formal demand letter, or canceling bond claim, something like that. So, all right. So questions. I did. You guys did miss this. I want to make sure you don't miss this, but I did have this nice picture here of my kids. Oh. Wow. Oh, maybe I have to do this. Didn't work. There it is. Okay. So I got a picture of my kids actually graduating from college. Want to verify that my client did help when I get through. All right. So any other questions?
Are there any restrictions or provisions, I guess, that at a general contractor level, can you impose more onerous conditions down on your subcontractors than the owner is imposing on you? Or do you have to balance what your prime agreement is with the owner to what you're flowing down to the sub?
The short answer, so the question is, can a general contractor impose more onerous restrictions on the subcontractor than the owners on them? And the short answer is probably yes. I mean, again, it's the idea that you can do what you want with your contracts. I'm not sure that's good business, but I've seen it. I've seen it where that happens, where people put in things in terms of performance requirements, time periods, things like that. There are laws that both Kansas, Missouri, and a lot of other states have passed to try to protect the lower tier contractors from that in terms of requiring. So, for example, if it said, so if a subcontract said, you cannot file a lien on this project. There are laws in Missouri and Kansas that say not enforceable. Okay? If there was a subcontract that said, I don't have to pay you for 100 days after I get paid, there are laws in Missouri and Kansas that say not enforceable. So that's good. But in general, there are things that, you know, in general, you've got to take everything in the contract pretty seriously and don't just take the attitude that, well, it's not enforceable. Yeah.
As far as ratification on claim, when you get a ratification agreement, you're looking at that like a contract because you're working with the bond company at that point. Can they be more restrictive on that ratification agreement compared to a contract?
In what way?
Like saying you don't sign a ratification agreement, they decide that they don't want to pay you, that they can, line item 1 on the ratification agreement?
Yeah, I mean, the ratification agreement.
I've already performed the work, I'm already done. Job is not complete, contractor goes bankrupt. Subcontractor going after a bond company. You know, they're big insurance companies.
So has anybody else dealt with a ratification agreement with a surety?
You know, once.
Okay, so let me just explain.
I couldn't do a credit report on customer work.
Yeah, so let me kind of explain how that happens. I just went through that on a project too. And so you work on a project, you've got a claim, you finished up your work, or maybe not.
Yeah, I did.
Yeah. And the contractor goes out of business, so a surety, the owner purchased a bond, so the surety comes in and has the obligation to finish the work. And what they will want to do is enter into a separate agreement with you where they agree to pay you directly. And, you know, that's really the opportunity then to negotiate all the terms that you want. I mean, in terms of what's owed, when you'll do the work, what the additional work is, and what it'll take.
The final contract with the provisions of the contractor,
Yeah,
you read the first line, it's still reflect.
yeah. I would say you just need to try to negotiate in that ratification, because you don't have to sign the ratification.
No, I can decide not to pay.
We still have a
It's
claim.
just make money, yeah.
We still have a claim.
It's just that my kids, it's a lot.
Yeah. Any other questions?
Maybe redundant, but I didn't catch the pay, if paid versus pay when paid. Could you help distinguish the two a little better?
Sure, sure. So the typical AIA says that that's the pay when. And what it says is you'll get paid when I get paid, which means, you know, I'm going to get the check and then I'm going to turn around and write all my checks to my subcontractors, right? And it says usually you're going to get paid within 7 days or something. Okay? Well, if that's in your contract and the owner files bankruptcy and the general contractor doesn't get paid, and you've got some bills sitting out there, does the general contractor have to pay you under those circumstances? The answer is yes. They would have to pay. If it says pay if paid, which doesn't have the word if in it, which is kind of a misnomer. If it says, you know, your payment is contingent upon receipt by the general contractor, or you bear the risk, etc., then if the owner goes out of business, then that's on you.
The pay when paid, that's still required.
No, pay when paid allows you to get paid even if they never get paid.
I can work with Jim.
So it's, you know, I would generally advise a subcontractor not to have a pay if paid, just because the fairly south, and I've seen, and where it gets really bad, if it's 1 month, that's one thing. Where I've seen it is, you know, well, we're slow, they're getting some more funding, and then all of a sudden you're 90 days out. And now that's a huge chunk of money, and the general contractors, of course they want you out there because they're not out, you know, they're not on the hook for that. And so, it would be one of those things that I would try to negotiate out. Or at least have a conversation with her, or at least know what you're getting into. All right? Any other questions? All right. Well, I've enjoyed it. I'll be right here if anybody has any other questions.